A single Supreme Court decision just opened a door that could change how millions of Americans own guns, and right now lawsuits are lining up to walk through it. If you've been paying attention, you already know something huge is happening. If you haven't, this video will catch you up fast. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to explain could save you from making a costly legal mistake. Hit that button now. Here's what just happened. In 2022, the Supreme Court handed down a case called New York State Rifle and Pistol Association versus Bruen. That one decision rewrote how courts decide if a gun law is allowed. Before Bruen, judges asked if a law was reasonable. After Bruen, judges must ask if the law has a historical twin, meaning, did something like it exist when the Constitution was written? If not, the law is in trouble. That single change has shaken federal gun law to its foundation. Pause. Now let's break down what's actually being challenged and what's already fallen. First thing to understand, federal gun law is mostly written into one statute called 18 U.S. Section 922. That section lists categories of people who cannot own guns: felons, drug users, people under domestic violence restraining orders, people convicted of domestic violence misdemeanors, fugitives from justice, people who have been committed to mental institutions, and a few more. Each one of those is called a prohibited person category. Each one says you can't possess a firearm if you fall into it. These categories have been on the books for decades. Most gun owners assume they are untouchable. They're not. And here's where it gets interesting. After Bruen, defense lawyers started filing lawsuits attacking Section 922 piece by piece. Not all at once, category by category, person by person. That's called an as-applied challenge. It means the law might be okay in general, but it's not okay for this specific person. And in the last 3 years, those challenges have started winning big. Let me explain why this matters with a real example. In 2023, the Third Circuit Court of Appeals decided a case called Range versus Attorney General. A man named Bruen Range had a nonviolent felony from years ago. He wanted his gun rights back. The court ruled that the federal law banning him from owning a gun was unconstitutional as applied to him. The court said the government could not prove that Range, a nonviolent felon, was dangerous enough to disarm for life. That was a massive crack in the wall. But here's the crazy part. Other federal courts are splitting on the same question. Some circuits say Section 922 still works for nonviolent felons. Others say it doesn't. That disagreement is called a circuit split, and when circuits split, the Supreme Court usually steps in to settle it. Right now, there's a petition pending at the Supreme Court asking them to do exactly that. It's called Smith versus United States. If the court takes the case, whatever it decides could affect every felon in America. That's not small. Pause if you're finding this helpful. My next video covers the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now, I'm not just talking about felons, the drug user category. That's Section 922 G3 is also under fire. A man named Mitchell was convicted under that statute, and in late 2025, the Fifth Circuit Court of Appeals ruled against him. The court said the drug user ban is unconstitutional as applied to someone whose only underlying conduct was simple marijuana possession. Think about that. A federal appellate court just told the government that disarming someone for using marijuana doesn't pass the Bruen test. That's huge, and it's not done yet. Mitchell's case, and others like it, are still moving through the courts. This is where you need to slow down and pay attention, because the same Bruen logic is being aimed at other categories. The Fifth Circuit has heard broad challenges to Section 922 as a whole. In a case called Lara versus Garland, gun owners argued that the entire framework of prohibited categories is unconstitutional. The court didn't strike everything down in that case, but the door is open, and more cases like it are coming. Pause. Let me break down the second piece of this puzzle. It's not just old laws on the books. New rules made by the ATF, that's the Bureau of Alcohol, Tobacco, Firearms and Explosives, are also being challenged, and some have already been struck down. Here's a hypothetical example to explain this. Imagine you buy a device that helps you shoulder your pistol more comfortably. A friend calls it a pistol brace. You register it as a pistol, just like the ATF said you should. Then the ATF changes its mind and reclassifies the same device as a short-barreled rifle. Now you might be a felon overnight. That's exactly what happened with the ATF pistol brace rule from 2023, and in 2025, federal courts vacated that rule, which means for now it can't be enforced against you. The ATF has even proposed repealing it. But here's the part nobody's talking about. The Supreme Court has been busy with gun cases too. In June 2024, the court decided a case called Garland versus Cargill. That case dealt with bump stocks. Bump stocks are devices that help a rifle fire faster. The ATF banned them after a 2017 Las Vegas shooting. The Supreme Court struck down that ban in a 6-3 decision. The court said bump stocks don't meet the legal definition of a machine gun, so the ban was overreach. 8 days later, the court decided another major gun case, United States versus Rahimi. That case dealt with Section 922G8. That subsection makes it illegal for someone subject to a domestic violence restraining order to own a gun. The man in the case, Zaki Rahimi, had a restraining order from a Texas court. He was accused of being a danger. The court upheld the law in an 8-1 decision. So in Rahimi, the court let the category stand, but it also gave lower courts a roadmap for how to test other categories. Let me explain why. That matters. When the court upholds one category but uses Bruen's historical test, it basically tells every other category you better have a historical twin. Some categories will have one, some won't. The drug user category is hard to defend historically. The fugitive category is hard to defend historically. That's why plaintiffs keep lining up. Pause. Hey, do me a favor. About 3 out of every 4 people watching this video right now aren't subscribed. Don't be in that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now there's a third battlefront that gets even less attention. Ghost guns. Those are firearms you can build at home from kits and unfinished parts. In 2022, the ATF issued a rule requiring kits and unfinished frames to have serial numbers, just like factory guns. Gun groups sued. The case moved through the courts and became Bondi versus VanDerStok on March 26, 2025. The Supreme Court ruled 7-2 and upheld the ATF rule. So ghost gun kits still need serial numbers, but that ruling was narrow. It didn't shut down other factory rule challenges. Make sure you understand this distinction. The Supreme Court has been swinging both ways. It struck down the bump stock ban. It upheld the ghost gun rule. It upheld domestic violence restraining order prohibitions, and it left the door wide open for as applied challenges to almost every other category. So you can't say the court is pro-gun or anti-gun. You can only say the court is applying the Bruen test very carefully. Pause. Here's the part that shocked me when I first dug into it. The federal felon ban alone, Section 922G1, affects an estimated 20 million Americans. Many of them have decades-old convictions. Many of them were never violent after range and the Fifth Circuit's more recent rulings. The door is open for many of those people to get their gun rights back through the courts. Did you know that? If the Supreme Court eventually agrees with the Fifth Circuit, suddenly millions of Americans could legally own firearms again for the first time in years. That's not a small policy shift. That's a generational change. But wait, there's something even more important. Even if Section 922 gets narrowed down, states can still have their own rules. Most states have their own felon bans. Some states go further than federal law. Some go less far. So the federal changes I'm describing don't automatically clear you in your home state. You still need to know your state law. Don't make this mistake of assuming federal change equals state change. They're separate systems. Now let me share something I've noticed while digging into these cases. The lawsuits moving fastest right now are not full-on attacks on Section 922. They're surgical as applied challenges. One defendant, one specific conviction, one narrow ruling. That's the strategy. Because if you try to kill a whole category in one case, you'll lose. But if you win 20 as applied cases, you build a pattern, and patterns eventually reach the Supreme Court. Here's a hypothetical example to make this strategy clear. Imagine a man who got convicted of tax fraud 20 years ago. He did his time. He paid his debt. He's lived clean ever since. Now he files a case saying the federal felon ban shouldn't apply to him. He doesn't try to free every felon. He just argues for himself. That case moves faster. That case is harder for the government to defend. And exactly that kind of case is moving through the courts right now. This information could literally expire, pending Supreme Court rulings, new circuit decisions, and new ATF rules are dropping every term. Subscribe now because my next video will cover one specific case that might flip a major category in the next year. Don't miss it. Let me also flag the bigger picture that most people miss. This isn't just about whether you can own a firearm today. It's about whether the whole architecture of federal gun prohibition holds up. For 50 years, Section 922 has been treated like bedrock. After Bruen, the bedrock cracked. After Rahimi, the court gave everyone a roadmap for more cracks. After range, after the Fifth Circuit's recent rulings, after Cargill, after VanDerStok, the picture is clear. Federal gun law is being rewritten right now in courtrooms. Not by Congress, not by the ATF, by judges. Pause now. Quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation, whether you are a prohibited person trying To restore your rights, a gun owner worried about new rules, or just someone who wants to stay informed, do not rely on a YouTube video for your final legal answer. Find a lawyer in your state who focuses on firearms law. There are more of them now than ever before. Here's where most people get this wrong. They hear that a federal court struck down a category. They assume the ruling applies everywhere instantly. It doesn't. Appellate rulings bind the states inside that circuit. They don't bind other circuits. They don't change your state law. They don't erase your state felony conviction. So when you hear a win in the Fifth Circuit, that win helps people in Texas, Louisiana, Mississippi. It might not help you in California or New York until the Supreme Court resolves the split. Geography still matters. Let me also flag the part no one is warning you about. The government is still winning some of these cases, not every. Challenge succeeds. United States versus Williams, decided by the Fifth Circuit in 2025, upheld a different prohibition section 922 G9 as applied to the defendant in that case. So even within the same court, different subsections get different results. The drug user subsection, under attack, the DV misdemeanor subsection, mostly surviving, the fugitive subsection, vulnerable. The pattern is unpredictable. That's why you need a lawyer, not just a headline. Here's what it all comes down to. Number 1. The Supreme Court has rewrote the test for gun laws. Bruen asks if a law has a historical twin. Number 2. Federal courts are now applying that test section by section. Some categories lose. Some survive. Number 3. The biggest live target is the federal felon ban. Millions of Americans are affected. Number 4. Drug users, fugitives, and certain misdemeanor categories are also at risk. Number 5. New ATF rules are being challenged and vacated. The pistol brace rule is currently unenforceable. Number 6. State law still matters. Federal changes don't replace your state rules. Number 7. The Supreme Court has not yet resolved the big split, but petitions are pending. Look, I spent weeks digging through federal appellate opinions, ATF rules, pending suit petitions, and circuit split analyses to put this together. The least you can do is hit subscribe to support the channel. Deal? If you found this useful, share it with another gun owner who missed it. This kind of legal shift doesn't get mainstream news coverage until something dramatic happens. By then, it's too late to prepare. Subscribe now so you're never caught off guard when the next ruling drops. And remember, this is educational content, not legal advice. Always consult a licensed attorney in your state for your specific situation. Gun law changes fast. The information in this video reflects court rulings and pending petitions as of mid-2026. Anything after that, you'll need fresh research. Stay informed. Stay legal, and I'll see you in the next one.